Hello everyone, and welcome to the second episode of Writ and Talk by the Center for Comparative Constitutional and Administrative Law from National Law University, Jodhpur. We're delighted to have you all back to continue this inquisitive journey. With the help of this podcast, the Center aims to bring clarity of idea and build discussion on constitutional and administrative law as well as academia. The Center aims to interview authors in this long-form podcast to go in depth with the themes and arguments they have raised in their published articles as well as throughout their writing process. Over to your host, Assistant Professor of Constitutional Law at NLU Jodhpur, Ms. Sayantani Bagchi.
I welcome all our listeners to the second episode of Write and Talk. We are immensely delighted to host Meenakshi Ramkumar and Aishwarya Singh, who have co-authored this brilliant paper on the rights of the opposition, highlighting how despite the significant role played by the opposition, the concern towards entrenching opposition rights in India still remain on the fringes of constitutional deliberation. I welcome Meenakshi and Aishwarya.
Thank you so much, Professor Bagchi, for inviting us. It's a pleasure to join you on this podcast.
Thank you. Thank you so much. Okay, so I would request the authors to go ahead with the introduction of the paper, because we all, as listeners, we intend to understand the trajectory that the authors have followed while writing this paper, what are the arguments that they have emphasized upon, and how they have gone about writing this entire research paper. So over to you. So if you could please briefly tell us what you have exactly dealt with.
Yes, thank you, Professor Bagchi. So basically, in this article, we have tried to analyze the constitutional designs of the parliamentary structures in India and South Africa. So we've essentially done a comparative analysis. And the reason we ended up choosing India and South Africa is because there are a lot of similarities between the two countries in the sense that both came up from a colonial past and have diverse societies and intergroup conflicts. But there are also differences in the sense that how the Indian constitution came into being versus how the South African constitution came into being. In the South African context, the constitution arrived as a result of negotiations and reconciliations between the two racial groups after the apartheid. And in the Indian context, we had this one party, essentially the Congress, kind of leading the framing of the constitution. So in this context, we've analyzed how both India and South Africa have taken two different roads to opposition rights, where South Africa has kind of institutionalized the role of opposition in the constitutional text itself by kind of codifying certain opposition rights. The Indian constitution chose not to do it. And perhaps the single party system that we had at that time, or the dominance of Congress, did impact this decision. And also, I think at that time, because of the context of partition, I think there was some sense of a centralizing bias that existed at that time. So that's why we have basically taken these two jurisdictions. And what we have said in this article is that because there's a codification of opposition rights in South Africa, the courts are able to play a more proactive role because there's a clarity on what these opposition rights are. Whereas in India, there has been a debate on, kind of having this judicial review of legislative processes that kind of comes into conflict with Article 122 of the Constitution, which says that, parliamentary proceedings are not justiciable. And also, apart from that, I mean, there have been instances where the Supreme Court has intervened or has kind of come up with these standards that, okay, that the court may intervene if something unconstitutional has happened. But that basically the application of the rule of the standards that the courts have developed has been kind of choppy. So at one instance, we have the Aadhaar judgment of Puttaswamy 2, and on the other, we have the Ashish Sheller judgment. So our primary argument is that in the absence of codification of opposition rights, this sort of reliance on courts uh, to kind of, intervene whenever the dominant party in the Lok Sabha violates the rights of the opposition, uh, will not really do well for our parliamentary structures, because it's not actually strengthening the opposition or parliament as a deliberative body. Rather, it's just kind of giving more powers to the judiciary to intervene in the political processes, which judiciary might not always have, have the ability to do so. So this is basically what we have kind of discussed in this article.
Yes, Meenakshi, would you like to say a few words?
Yeah, so just in terms of how we actually started writing this piece itself, so at the time we were writing this piece, the issue of opposition rights was quite topical because there was an ongoing dispute at the central level with the Rajya Sabha and the suspension of certain members of parliament. And then there were deliberations in the public domain on how we can safeguard or better safeguard interests of the opposition in the parliament. And subsequently after that, in the state of Maharashtra, we had seen a similar instance occur, and the Supreme Court had stepped in around that time and gave a judgment in the in the case that Aishwarya was talking about. And essentially, what we noticed when we read the judgment, and the judgment had come out in January, was the use of provisions from from Part 3, that's the fundamental rights aspect of Articles 14 and 21, instead of actually looking at institutional solutions to safeguard the rights of the opposition parties in the parliament. So that's where our thought process started to, we started to think about how you can conceive these, structural conceptions of safeguarding oppositional rights. And so we started looking at other jurisdictions to see how they have done it. And actually, IDEA International had conducted a study a while back on protecting, on constitutionally protecting opposition rights and recognizing the leader of an opposition. And so we were looking at that study, and that's when it struck us that to see how the South African model, and then compare the South African model with the Indian model, and see and also understand why the two countries came to these different solutions, or this different provisions in the constitution to deal with opposition rights. So I think Aishwarya explained the sort of two jurisdictions very clearly. So I think nothing further to add on that.
All right. So here in the concluding part, while I was reading this paper, there's a very interesting thing that you've pointed out, where you write that in the face of a powerful majority in the parliament, the opposition may not be able to block the agendas of the ruling party. Then, whether there's any benefit in institutionalizing the rights of the opposition. And then to answer this, you have also written that the opposition can stand as a wall between the majority rule and the tyranny of the majority. So I'm actually very curious about understanding if there are some objectively identifiable ways to actually consolidate this particular position that the opposition has in India, because it's pretty much scattered, and there's no clear-cut recognition neither in the constitution nor anywhere else, or even informally when it comes to the conventions as well. We do not see any clear-cut, protection being given to the opposition. So, are there any, a set of identifiable standards that you can, talk about here?
Yes, Professor Bagchi, one thing that struck us while we were, writing this paper was, one way to look at it is a constitutional amendment, which is a legal process. But apart from that, if you have to sort of, cull out values of the Constitution and use those values in sort of understanding that the need, first recognizing the need and importance of the opposition to protect those values that our Constitution enshrines, and then using those values as a sort of conceptual framework to then start, recognizing this opposition, at least informally or through, judicial norms, but that may not be sufficient. You may still need some level of statutory or constitutional backing to ensure that those values are protected through the operation of the opposition in parliament.
Okay. Thank you so much. So, moving on to the next question. So, in your paper, you have talked about how the opposition keeps the majority in check, which is definitely the job of the opposition. So, recently, as we have seen that there has been an active discourse on increasing representation of vulnerable communities in the legislature, especially during the farmers' protest and the anti-CAA protests. So, do you believe that such a proposition is beneficial for the democratic setting? And if so, do you believe that there is a space to include this particular change?
Yes, Professor Bagchi, one thing that may be important to note is globally we see this trend right now where you can say representative democracy is in a crisis. And some of the reason, some of the indications of this is you can see low voter turnouts, you can see a larger distrust in politicians, and a sort of lack of accountability from politicians towards its electorate, right? And often this crisis, or sort of the representative democracy being in a crisis, is something that we do see time and again in history and globally as a phenomena, not particular to the Indian jurisdiction, but it's a sort of cyclic thing that we do notice. And somewhere maybe this stems from the very features of a representative democracy itself. And political theory scholars like Nadia Urbanati and Mark Warren have sort of identified some of these features that could be problematic. And the sort of first feature of an ideal representative democracy that they highlight is that representation is sort of understood as a principal-agent relationship, where essentially the principals are the electorate and they are electing their agents to act in their interests. And sort of another feature that they highlight is that the electoral mechanisms, what they're supposed to do in a representative democracy is ensure that there's some level of interaction and some responsiveness between the principal and agent between elections. And it shouldn't be that the principal-agent relationship is something, or you see interaction between these two elements only at the time of election. And a third sort of thing they highlight as a sort of feature of ideal representative democracy is universal adult franchise to ensure that there is political equality. However, as we notice, in a representative democracy, just having universal adult franchise is not going to ensure political equality, right? Because you do have interests of minority, vulnerable, marginalized groups that will not be represented adequately because of the majoritarian system on which a representative democracy thrives. So often there are sort of avenues that you can think of to bring in better representation of these marginalized, vulnerable groups, and two possible ways to think about it is proportional representation and quotas or reservations. When it comes to proportional reservations, the Constituent Assembly shot it down and said that it's too complex a system for the Indian context and therefore we cannot adopt it. And when it came to reservations, they left that as an open space for us to think about, because under Article 330, you do have reservations for scheduled caste, scheduled tribe members, but with joint electorates. Now, this feature of joint electorates was actually criticized by some members of the Constituent Assembly, like S. Nagappa, for instance. He had mentioned, he's actually reiterating one of Ambedkar's earlier iterations, which he made as a demand during around the Pune Pact of 1932. And what Nagappa says is that just having reservations with a joint electorate has two problems. First, the candidate may not actually be representing the community that they seek to represent. And two, there will not be an accountability to the scheduled caste, scheduled tribe electorate. Because if you had to look at it in that principal-agent relationship, if you have a joint electorate, the agent is representing not just the scheduled caste, scheduled tribe communities, but also the other communities who have voted in that constituency. So, what Nagaba actually suggested that could be done was, apart from just ensuring that the candidate has a majority of votes in that particular constituency, the candidate would also have to secure 35% votes from the scheduled caste, scheduled tribe communities. So it's sort of a measure to ensure that there's some level of accountability to the electorate that they're seeking to represent through this reservation process. But once again, that was shot down. So all that we're left with is reservations in a joint electorate system. So you do have space to sort of ensure there's better representation of marginalized, vulnerable communities through this reservation provision. However, there are issues in terms of looking at representation only as representation in parliament without actual decision making power or ability to be able to influence policy and law making. So another sort of, we can think of alternative ways in or mechanisms in which we can include these marginalized and vulnerable groups to ensure that there is more substantial participation in lawmaking through public participation forums. And there are so many innovations around us globally when it comes to ensuring better public participation. For example, if you take the context in Ireland and the context of citizen assemblies, and when these citizens assemblies are sort of formed to ensure there is deliberation and participation of various communities, what ends up happening is you're able to carry out an exercise of consensus building. Even on contentious issues like abortion, they were able to garner that a sort of public will and consensus building to be able to push the government to act in a certain manner. So if we can design alternative institutions that ensure there is sound deliberation and participation from marginalized and vulnerable communities, and we can build consensus, then I feel that that alternative avenue is something that could be explored and may serve as a very sound and robust method of representation for marginalized communities.
Okay, thank you so much, Meenakshi, for that answer. Now, coming to another important facet that you've highlighted here, and that is, you've talked about the limitations imposed on the Rajya Sabha and how its constitutional standing and the legislative powers it enjoys are less as compared to the Lok Sabha, and how that kind of affects the standing of the opposition. So, do you think that such a setup is primarily detrimental to the democratic interests of our country? And if so, do you think that any other model, let's say something like that of the US model, where the houses enjoy more or less similar powers, that would be a better way for the legislative bodies to be structured to ensure mass democracy? So, what is your take on this?
So I think before I start answering this question, um, I think it is a feature of Commonwealth parliamentary systems where you have like a strong lower house, and then you have the upper chambers or the upper house, which functions mostly as this body which kind of scrutinizes or deliberates on the proposals of the lower house, but doesn't really have any effective pushbacks against the proposals that come up through the lower house. I mean, this is the same situation in the UK where the House of Lords also kind of exercises only a suspensive veto over the proposals of the lower house, especially if they are if something is a part of the manifesto of the ruling party, then the House of Lords is not going to block it. I think this is the Salisbury Convention, and then you have these other parliamentary acts which kind of say that the House of Lords can basically exercise a suspensive veto where they can only kind of send the legislation back for reconsideration, and then when it comes back to them, then they have to kind of approve it. So it's like they can just prolong or delay the legislation. So I mean, what I'm trying to say is that this is not just a feature of the Indian system, but it is actually common in other Commonwealth parliamentary systems as well. Um, and I think the reason for that is, and it's interesting that you talked about that, should we change how the Rajya Sabha has been structured in terms of its power to have, to have better mass democracy. So in that way, I think the issue here is that Rajya Sabha has never been thought to be this body which kind of embodies mass democracy. It's actually the lower house, which is typically considered in Commonwealth parliamentary systems to be this embodiment of the democratic will. And because of that, the upper chambers or the upper houses don't really have, so much of powers, so to say, because they do not enjoy that sort of democratic legitimacy. And in the context of India, the Rajya Sabha is indirectly elected, so it's actually not elected by the people. So I think these are the reasons why the upper chambers or the upper houses lack that sort of power which the lower house might have. And US is an interesting example because perhaps it has one of the strongest upper houses or the Senate that that is there. And Senate was also indirectly elected before, but now it's after a constitutional amendment, it's directly elected by the people. So I think that's why it enjoys more democratic legitimacy. So I think that is one of the reasons why the US Senate has more powers as opposed to these other upper houses and other Commonwealth jurisdictions, which do not, have that sort of democratic backing, so to say. And I think the other reason why the Senate is more powerful in the US is because of the strong federal character of the US political system, where the states have kind of come together to form this union. But in India, I mean, we do have a slight unitary bias where the union is kind of like holding the states kind of together. So because of these reasons, I think the Rajya Sabha does not enjoy the sort of powers that the Lok Sabha would. But the Rajya Sabha does play a very important role, which is that it is a deliberative body again, which kind of acts as a check on the Lok Sabha, because many times the composition of Rajya Sabha, because it's a permanent body, does not kind of mirror the composition of the Lok Sabha in terms of who is in the majority, who is the dominant party in the Rajya Sabha, because Rajya Sabha is more fragmented because of the rise of these regional parties in different states, and you have more multi parties, having this sort of different blocks in Rajya Sabha, sorry. Because of that, I think the point is that there's an institutional design that is why we chose to have the sort of upper house that we do. And it does make sense. And if we take as the baseline that, yeah, we are in a parliamentary system and this is a parliamentary federal chamber, where the union has more of a centralizing role as opposed to the US system, which is a presidential unitary system, presidential federal system. Then we can kind of make sense of these differences. I think the issue lies uh, in not allowing the Rajya Sabha to function as it should, which is where you have this dubious classification of money bills, and you do not allow debates to actually take place in the Rajya Sabha. You allow proposals to just pass without having any, proper voting on them through voice votes. So, because of these issues, the Rajya Sabha has been compromised, so to say, and this has been going on for a long time. It's not just unique to the times that we live in. But I think just ensuring that the institutional safeguards that are there, the powers that the Rajya Sabha does have to delay a legislation, to debate on a legislation, to allow a legislation that has been passed by the Lok Sabha to lapse, these are the things that we are not, allowing to happen generally. So I think that's where the fault lies. And it might not be all right to just import the US model, because it's situated in a very different context and in a very different conception of a political system.
All right. Thank you so much, Aishwarya, for this answer. Also, with regard to this particular power that is vested on the leader of the house, specifically, when we talk about the speaker. So you've mentioned in your article that the power to recognize the opposition leader, it vests with the speaker, and that for 2 consecutive terms, a leader of opposition has not been appointed. So what role do you think is the position of the speaker, who has been given various discretionary powers which are often used to further the agenda of the party in power plays, right, that you have mentioned in your paper. So do you think that there has to be a change in the process, and how do you wish to bring about this change, especially when it comes to the leader of the opposition, who, according to you, serves or is placed in a very, very vulnerable position. And interestingly, as you've pointed out, he has not even been appointed for 2 consecutive terms at a stretch. So how do you think this can be addressed?
Yeah, sure. I'll take that up, Professor Bagchi. So just before I start on the process of appointing the leader of an opposition, I thought let's just take a step back to look at what the role of the leader of the opposition is very briefly. So many democracies that are sort of modeled on the Westminster system have something called a shadow cabinet. So essentially, just as you have the Prime Minister and the Prime Minister's cabinet, you also have their counterpart in the form of the leader of opposition, and a shadow cabinet which consists of senior opposition members of parliament. And essentially what the role of this shadow cabinet is to sort of express the opposition policy with respect to particular portfolios. So for example, in the Canadian context, if you have to look at it, you can see that you have like these opposition spokespersons of sorts who are called critiques. So if you have a Minister of National Defense, the Minister of National Defense is essentially shadowed by a defense critique. So as the name sort of gives you an idea, so the role of this defense critique is, yes, to criticize or critique the policies of the government vis-a-vis defense, and also to scrutinize the activities of the government in that particular area, in that particular portfolio. But that's not the only job of the defense critique. So what essentially this shadow cabinet is doing is also, it's like this alternative government in waiting. So when the government loses its majority in parliament and this shadow cabinet is able to prove majority in parliament, they sort of take over. In India, while we do not follow this strict system of a shadow cabinet per se, we have recognized a leader of opposition in parliament since the get-go. And while this leader of opposition is not a constitutional office, up until 1977, it wasn't a statutory office either. And the leader of opposition was merely appointed under a directional order of the speaker. The first speaker actually came up with this directional order, G.V. Mavlankar. And what this order, among other things, said was that the leader of the largest party in the opposition would be appointed as the leader of the opposition, provided that the party has a strength that is enough to constitute the quorum for sitting of the house, or is 1/10 of the total membership of the house. Now, because of this rule, until 1969, there was no leader of opposition in the parliament. It was only in 1969 that the first leader of opposition was appointed. And subsequently, in 1977, you had a statutory recognition of the leader of opposition in the Salaries and Allowances of Leaders of Opposition in Parliament Act. In this act, essentially, the leader of opposition was defined to be a member of either the Rajya Sabha or the Lok Sabha, who was the leader of the opposition party, having the greatest numerical strength and recognized by either the speaker or the chairman of the Rajya Sabha or the Lok Sabha, as the case may be. So the fact is that it's not just enough that the leader of opposition was the leader of a party with the greatest numerical strength in the opposition, but was also required to be recognized by the speaker or the chairman of either House of Parliament as the leader of opposition, and that's where the discretion lies. And because this discretion lies, what has happened is, even after the statutory provision sort of recognizing the leader of opposition, the speaker still relied on the directional order of having the 10% rule. So, even actually subsequently, I think in 1980, between 1980 and 1989, once again the leader of opposition position was vacant in parliament because of this particular rule. Now, while this discretion is there, clearly the speaker has the discretion to either follow the directional order vis-a-vis the 10% rule or not follow that. And it would seem prudent that in the particular circumstances, given that you're just in today's situation where you require to have 55 members and a party has only 52 members, with just those three seats, you could have easily waived, you could claim to have, easily waived this requirement in lieu of the larger constitutional values that you seek to protect by having this leader of opposition, which is a rule of law, accountability, transparency, which are all values that are entrenched in our constitutional system. But unfortunately, because there is no constitutional provision, there is no means of pushing the speaker to even exercise this discretion. It's not justiciable. In Canada, however, interestingly, I think it was in British Columbia, if I'm not wrong, in the 1930s. So they had a similar provision with regard to recognizing the leader of opposition. And the recognized opposition party had actually lost a seat after a by-election, which actually resulted in another party becoming numerically superior in the opposition in the House. But the speaker determined that for the sake of convenience, the official opposition would not change. So clearly the speaker here had exercised some level of discretion in sort of, considering the larger requirements of the functioning of the parliament and the democratic society as a whole in making that decision. And while the same we're not able to push for that in the Indian context because of the lack of a constitutional provision that can even give some level of justiciability for requiring a leader of opposition in the first place. If you look at the South African context, under Article 57, so Section 57(2)(d) of the South African Constitution, it says that the rules formulated by the National Assembly must include the recognition of the leader of the largest opposition party in the assembly as the leader of the opposition. So the rules pretty much use similar language. It says that the leader of the largest opposition party in the assembly will be recognized as the leader of the opposition as contemplated in the constitution itself. And if you look at, for instance, the Pakistan context for appointment of leader of opposition, their rules of procedure require a submission made by the opposition, nominating a member or a member as the leader of the opposition. And essentially, this member would be a leader of the party of the greatest numerical strength. So this, once again, while the appointment is still made by the speaker, there's some level of way to push the speaker to act in a certain direction, which is lacking in the current framework in the Indian context. So this is an example of how, because of deficient constitutional rules, what is essentially happening is you're excluding the opposition at a time when you're actually, because of the small size of opportunities, need to recognize the leader of the opposition to ensure that there is democratic dialogue and deliberation in the parliament. And so in order to avoid such a situation, I think it should be made clear because we only have a statutory provision now. So to be made clear in the statutory provision that there is no minimum number of members as such necessary to support a leader of the opposition. And this would also be actually sound in tandem with the anti-defection provisions in Schedule 10, because a party to be recognized as a party in the parliament doesn't need to have a certain numerical strength. So in that case, why does an opposition party then have that additional burden to show that I am an opposition party by having a certain number of seats? So I think this is a change that needs to be made statutorily and can be made statutorily for the time being until we do think of other mechanisms to recognize the leader of the opposition.
Thank you so much, Meenakshi. Now, we will come to the last question of ours, and we have two parts to this question. Now, you have talked about the institutionalization of the opposition's position in the political process. Now, what we intend to know is that, is it possible to have or to produce a taxonomy of constitutional provision that would create regimes of opposition rights at a global level? So is that something that is a feasible idea? Also, the second part of the question is that while reading your paper, we've understood that there is some kind of a reluctance that you have shown towards accepting unwritten doctrines as a mechanism to institutionalize the opposition rights. Now, because the parliamentary form of government that we follow in India has a huge bearing. I mean, it draws a lot of inspiration from the Westminster model, where unwritten doctrines play, a huge role. So, do you think unwritten norms can play a role in kind of establishing or entrenching uh, the position of the opposition in India, or it's better that we go for codified constitutional texts or amendments in the constitution, or explicit statutory recognition? So what, according to you, should be the right way of institutionalizing the opposition rights?
Professor Bagchi, I'll take the first half of the question. So, just with regard to the taxonomy of constitutional provisions at a global level, I think we can look at some examples of constitutions which do have an entrenched opposition rights sort of framework. And obviously, to start off with, is a sort of very broad brush idea, value based conception that's there in the South African constitution. If you look at Article 57 of the constitution, it clearly states that any rules or orders that are made regarding the conduct of business at the National Assembly, they will be made with due regard given to the values of representative and participatory democracy, accountability, transparency, and public involvement. So this is a very broad brush sort of way of entrenching it. And what this gives courts an opportunity to at least do is interfere when these rules do not adhere to these values, because they are required to adhere to these values from a constitutional perspective. There are other conceptions of how we can entrench opposition rights in a constitution as well, and it's done through various mechanisms. One way is ensuring representation in parliamentary committees. Now, this is also done in a very broad stroke way in the constitution of Malta and Madagascar, for instance, where they're saying that the representation should somehow the representation in the parliament should be represented, or should sort of be encapsulated even in the composition of parliamentary committees. Similarly, you have provisions for a committee of inquiry, where, for instance, like the Constitution of Georgia, which allows investigatory commissions to be established by 1/5 of the members of parliament, with an approval of 1/3 of the members of parliament, to be launch inquiries against the government. And then there is another concept of appointments in fourth branch and integrity institutions, which is there in the Indian context as well, but it hasn't been constitutionalized. Some constitutions, in fact, even give some form of, veto provisions, where, for example, in Sweden, if there is a legislation affecting fundamental rights, about just as few as 10 members of parliament from among 349 members of parliament can stall that legislation for a period of 1 year. And another very interesting form is, in a way, giving credence or sort of deference to the judicial mechanism is where some countries allow a certain legislative minority to refer a certain bill to a constitutional court or its equivalent for ruling on its constitutionality. And this is there in the Constitution of France, for instance. But when we're thinking of all of these designs, we'll have to be very careful of, one, the context, and borrowing from these countries cannot be done blindly. It needs to be done after evaluating of what's the possibility and feasibility of implementing that in the Indian context. And then you would also have questions of the thick and thin, in the sense how elaborate should these mechanisms be in the constitution, or can you make it broad brush and then ensure that there is sub-constitutional, statutory, or executive rules that are sort of culling out the details of this skeletal framework that is there in the constitution.
Right.
Aishwarya, do you want to take the second half of the
Yeah.
question?
So I'll take the second half of the question. So in our article, we have argued that there's a need to codify opposition rights, and we have primarily done it for the reason that we feel that in the absence of codified constitutional provisions, any judicially created doctrines. Right now, we have the standard of judicial intervention in legislative process if it's gross, if it suffers from gross illegality or if it violates unconstitutional provisions. So that is the standard that we have. But again, it's also kind of a vague standard, and that's why you have this uneven application. So that's why we argue that you need the codification so that you don't have this, this application of this, of this judicial standard. And because this application of this standard could be arbitrary and it could be completely dependent on the judge in question. And in some ways, it could also violate, this idea of separation of powers between the judiciary and the legislature, if such a standard is applied too broadly. So in that way, we feel that it is also important, and you brought up UK. It's also important to codify such opposition rights because we don't really have this established idea of conventions that the political actors should follow while conducting themselves in Parliament as opposed to the UK. And these conventions in the UK have a constitutional status. Although they are not judicially enforceable, that's generally the understanding, like that's what Dicey, who actually first kind of wrote about them, said. They are not judicially enforceable, but still, they are kind of universally followed, and if, a political actor does not follow them, he's kind of sidelined politically. He or she is sidelined politically. So that's why, because we do not have these constitutional conventions, and what we have is a big C constitution, some scholars use these definitions of having big C constitutions, which are these, there is this one legal document, which kind of contains all the constitutional provisions as opposed to the UK, or, which could be characterized as a country having a small C constitution where you do not have this one single document that contains all the constitutional rules. So in a country where you do have the Big C constitution, I think it is useful for these, for the constitutional provisions to clearly specify, what sort of rights are given to the opposition in the country. And other than that, it's also important that, the constitution does not just become a text which is interpreted by the courts, but it should also be a text, which the other organs of the state follow and understand. So if there is no codification of, the rights and duties in the constitution itself of how the majority party is supposed to behave or how the opposition is supposed to behave, then it would be really difficult to, ensure some sort of a compliance, by the political actors of these rules. It's very much possible that the court may say something, but the legislature or the political actors may just get around it or not really follow it. And this kind of over reliance on courts to act as a check on the political processes, or is also kind of misplaced, because if the court is not doing that, which is also not its job, because it's not a question of enforcing fundamental rights. It's how political actors are supposed to behave. If the court is not intervening in something like that, then what you would want is that the political actors are empowered themselves to protect their rights, and for that, this sort of codification is important. And the public will also know that these rights are something that the constitution itself provides. What we have right now is a very scattered governance of the legislative process. You have some speaker directions, you have some rules of conduct for the business of Lok Sabha, then you have this statute which recognizes the leader of opposition. So in this kind of context, there is no clarity on whether, whether a certain conduct is actually violative of, the constitutional ideal. So that's why I think it's important to have this codification of these rights.
All right. So we come to an end of this discussion, and I think this was absolutely brilliant. And this discussion has come at an opportune time, because when it comes to opposition rights, we have seen a number of times that even within the parliament and outside the parliament, uh, of course, the opposition, after years of indifference, the opposition has reacted in a different manner, and also the approach adopted towards the opposition, even that is something very very difficult to analyze, because there has not been any consistency. There have been, I mean, the concern has been majorly that of indifference. So, of course, generally when we see the protests and disruptions within the parliament, of course, these things are pretty much alarming. And as a result of this, we see that the opposition has found its place, let's say, before the media, which is 24/7, trying to cover these stories. So generally, that is something which is very unfortunate, because opposition, if constructively accommodated within the political domain, within the political space, I think that would contribute the most towards building democracy in its true term. So thank you once again, Meenakshi and Aishwarya, for sharing the absolutely intriguing insights with all of us. I'm sure we all have enjoyed the session thoroughly. Thank you once again.
Pleasure is ours, Professor
Thank you so
Bakshi.
much for
Thank you
having
for
us.
having us.
Thank you so much.